Ms. Msizi,
Good afternoon, Mr. Chair.
I noticed that you were a prosecutor, am I right?
Yes, that's correct.
For how long?
Only 4 years, Mr. Chair. It was between the time I finished my BJuris and I was preparing to proceed to do my LLB
Yes.
and to raise funds.
Oh, yes.
Yes.
And, well, to go straight to the High Court level, you've acted as a High Court judge on a number of occasions, is that correct?
That's correct, Mr. Chair.
Did you
I have.
enjoy it?
So, excuse me?
Did you enjoy it?
I did, CJ. I did, even though it's got its own challenges, but it is a good experience. I still am enjoying it.
Did you find some benefit from the aspirant judges program, or do you wish it were structured differently?
Definitely, CJ. I learned quite a lot, especially with regards to judgment writing. And I got a few tips from there, in particular, how one zooms into issues, but also just the structure of writing a judgment. And also, I got comfort from the knowledge that one must just adopt one style. You can learn and pick and choose from others, but be comfortable in your own style as long as you are making sense and grappling with the issue that is before you. I did find it quite instructive.
And what is the longest period over which you kept a judgment reserved?
I've been so far able to deliver my judgments within 3 months.
3 months.
Yes.
Yes. Well, just in your own words, just how ready are you for permanent appointment? I understand you people who practice law make a lot of money than we used to when we practice the law. Are you prepared to take that cut?
Unfortunately, CJ, I'm not one of those that's really moneyed.
Okay.
Though I must hasten to say I really enjoy the practice of law. What I've discovered as an advocate is that I enjoy sitting in my chambers and researching. I enjoy writing. I enjoy having discussions with my colleagues, in particular, just to understand and get people's views on things.
Yes.
I found that quite a great experience for me. As a result of that, utilizing that model, which is what is used at the bar, I
Yes.
found acting was therefore not a different environment. So the shock of an unfamiliar environment was therefore eliminated.
Yes.
And I am ready to be a judge.
What is it that prepared you? That's what very briefly, what is it that prepared you?
It's, firstly, I found that, especially because I've also acted, I'm familiar with most of the judges in my division, wherever they are, in PE, Grahamstown, and so forth. And I have found that they are very receptive and supportive, which also assists a lot in terms of just feeling at ease. That's one. Two, I have also enjoyed sitting up there and learning the art of cutting through the chase, if I may say, and how that asks of me to tap onto a different, at the competencies I already have as an advocate, but at a different level, in that I have now to make the final decision. I've become the final arbiter. I found that a challenging aspect, but also very intriguing and very energizing. I've really enjoyed that. And I believe that, CJ, given the variety of the matters that have come before me, also given the variety of given that I have gone to the various centers, that is Mthatha, and the rest of the other courts, I found that also the variety of the nature of matters that are dealt with in the various courts has also empowered me somewhat.
I noticed that you've occupied one leadership role or position or the other. How did you manage to rise that high in this male-dominated world?
Which one? Where?
Well,
what
you were,
is
for instance, the secretary of is it Advocates for Transformation, and also you were you were the chairperson of the women's chapter of Sansco at some stage. What is it about you that enables you to pierce through the barriers that tends to keep women from rising?
CJ, I don't know. I'm an only child. And when I was growing up, my father always instilled in me that I must be able to fend for myself. And that's what when I think back and look at my childhood, I always think that that's what I can really attribute to my having been able to allow even intimidating and unnerving circumstances not to intimidate me into inaction, but rather to intrigue me enough to want to step in there and learn for myself and take the bruises along with me.
Finally, and very briefly from your side as well, I read an article recently by a colleague of mine, a retired constitutional court judge, said one of the challenges that he has been struggling with, and I didn't pick up anything to the effect that he has overcome it, is that women and men are equal. What is it that you can do to help break those stereotypes or unconscious biases? Because sometimes we have a bias, but we don't know. And until you know, you can't do anything about it, or you can't do much about it.
That's
As a
correct.
woman, knowing the challenges that women have to confront, what is it that you can do to help us deal with this thing and deal with the gender question, even within the judiciary?
CJ, maybe I should, in answering, refer you to my stint as an executive at the Kuha project, where I was responsible for, amongst others, human resources. And the question of a diverse group, the diversity in the employment arena was always uppermost. And it was something that, as an executive responsible for ensuring that, I was always compelled to deal with it. And I found, CJ, that one of the techniques that, or rather strategies that one can adopt, is to allow a space for that diversity. And to do that, I need to first and foremost ensure that I am able to apply myself at a technical level, and I'm able to meet my male colleagues toe to toe, if I may say, and so that one looks at me first as a professional, and I'm able, once I've ascended to that level, I'm also able to therefore gain a voice, a strong one at that, of saying, I'm a woman, and you didn't even notice. When you engaged with me as a professional, you didn't even notice. So that then we don't use the issue of gender as to suggest that be more sympathetic, be more understanding, we shouldn't apologize, because we have the same capability, we have the same intellectual capabilities, and I think we just need to have the confidence to speak out and to state our point of view and not look at, unless of course, CJ, the issue of gender is the core of that debate or that discussion. But for instance, I'm coming here wanting to ascend to the throne as a judge. And what is required of me, of a person who is a judge, the academic qualifications, the independence of the mind, the ability to listen, all those things. But guess what? I'm also a woman. And of course, I'm not going to downplay the fact that I'm a woman, but I'm not wanting to use it as though I'm suggesting that because I'm a woman, you must overlook some of my weaknesses, because then it takes away from what I'm aspiring to get to.
JP?
Thank you, CJ. Sissy, a few questions.
Thanks, Jay.
I'm not aware whether you know the comment that came from the Grahamstown part of the Eastern Cape Society of
I am
Advocates.
JP.
And you know it's slightly different from the PE part.
Yes, JP, I'm aware.
Now, that is one society, except that some people are in Grahamstown and others in Port Elizabeth. Now, what is it, if you know, that could inform the difference between what they say about you, even though it does look there is a compromise somewhere? But what is behind that?
JP,
Others saying you have no experience, this is what they said last time, to be a judge, and others saying, no, you do have that experience, and we are working with the candidate. So Grahamstown might be wrong. Why should they commit themselves if there's a likelihood they might be wrong?
When I read that comment, JP, I first thought, how do I read into this thing? How do I read into the comment? I've of course had to take what they say is the reason for their reservations. And the reason they have advanced is that this person has been working in the Port Elizabeth court for most of the time, and therefore she is known better there. I thought then the converse is that she hasn't worked here that much, but to the extent that PE is confident that she is ready, therefore our reservations about her experience, her knowledge and readiness must therefore take secondary position, because we have enough confidence in Port Elizabeth. I'm really not able to tell JP why they are taking the stance they're taking. I'm just limited to what is in their comment.
The other question I thought I should put to you is what one is picking up from the street, I must say, strictly speaking, which is the period you spend with Kuha development.
Yes.
There is a suggestion that you have been away from law practice, and they normally say for 14 years.
Yes.
What period is it, by the way?
I
Doesn't amount to 14 years from what I can see.
JP, I think it really depends on what is exactly meant by being away from the practice of law. And I'm saying this because
No, we'll get to that.
Oh.
But I just want physically.
Oh, okay.
Physically, were you away for that long?
I left private practice at the end of 1994, and I returned in 2008 to commence my pupillage, and I've been back since then, JP.
Then that gives you what time?
94 to 2008, that would be 14 years, I think. Because it is 14 years, JP.
What kind of work were you doing there? Was it something completely away from law? Because when I'm looking at this, at what you have written, when you said Kucha Development Corporation, and then that's 2001 to 2008, and before that it's 2000. But were you not doing duties which are associated with law anyway?
When I was first employed, JP, I was employed as both the company secretary and the legal services manager. In both, and at the time, I've tried to explain it in my answers to the questionnaire. At that time, people would remember that the project had just started off. There were about 15 of us, for instance, at the time. And there were still a lot of systems that had to be put in place. For instance, the ensuring that the proper constitution of the company, the registration of the company, the setting up of the letterheads and so on, and even working with the board at the time and assisting it assisting the members of the board. But also very important is that this was also at the time, this is now JP in 2000, this was also at the time when there was a lot of new legislation that was coming up, very crucial legislation. And it was also just after the introduction of other new legislation, for instance, the Labor Relations Act. It had not been promulgated for a long time. And as an incumbent charged with legal services, I had to provide the organization with a lot of guidance, Basic Conditions of Employment Act. Similarly, then you also had legislation like the PAJA, the Promotion of Administrative Justice Act. You had PAYA, you had the PFMA. There was a lot of confusion, for instance, at that time in the organization as to whether it should be regarded, when it looks at this legislation, is it bound by the company law only, or is it bound by the company law read
In other words,
together
you have
and
always been associated with law.
I always have been. I always have been. I would be responsible, for instance, for litigation, and I worked with counsels I was some pseudo instructing attorney in engaging with them, because it was important for me to ensure that you don't, in instructing counsels and attorneys in doing legal matters for the organization, you don't take a distant position, because how else do you on a day-to-day guide the organization? So
Last question for me. Well, I must ask the question of reserve judgments, outstanding judgments. What is it like? What is the picture like as we speak?
I've got about 4 judgments, JP.
How old are they?
They are from the end of February, and 2 were now in March.
Have you been going on in that fashion? Not judgments, not older than 3 months?
Yes, that's my track record, JP.
Thank you.
Thank you,
CJ.
JP. MEC?
Thank you very much, CJ. A very good afternoon, Advocate Msizi.
Good afternoon.
Just 2 areas. Would you please clarify for me these statements in the questionnaire?
Yes.
The first one is on the fact that 6.2 proportion of your litigation work has been in the field of criminal law, and you're saying I was last involved in a criminal litigation in 1994. Then link up that with 8.1. Have you acted as a magistrate? The answer is no. Then link that lastly with 9.3. Did you sit in both civil and criminal courts? The answer is yes. And you're stating criminal cases there. that you have presided over at the last three institutions. Now, to a layman like me, I'm unable to make the link. Last time it was 1994. I've never been presiding. I've never been a magistrate, but I've been dealing with criminal cases when earlier I last did them in 1994 as an attorney. That's the first one, CJ. The last one. If things go well, Advocate Msizi, and you appointed as a judge, one of your responsibilities is not only to issue out judgments, but is also to help the system, to improve the system as part of transformation. In your own opinion, which other areas still need transformation in the justice system from the view of a judge? Thank you.
Thank you, MEC. Let me start with the first one, just to explain the context. With regards to my experience in criminal matters, as I've stated, at the time I was practicing as an attorney, I did undertake defending criminal matters. But then when I left practice, I was not involved in the criminal court at all, as I was not involved in the practice of law. Then on my return as an advocate, I also did not do any criminal matters. But from the time I started acting in 2013, I have been working in the criminal court. To this day, for instance, I've got a part head that I started last year, which I'm still going to be continuing as a part head in the June recess. So I now have been, at least from 2013, attending the criminal court as a judge. I've never, as indicated in my CV, I've never been a magistrate, but as a judge I have presided over criminal matters. Then coming to your second question, MEC, I think for me, the start with what could be done to change, before I embark on the answer, do you mind, MEC, just repeating the second question?
Beyond giving judgments as a judge, if you will, other areas, there still has to be transformation going on. Which other areas need transformation in your opinion?
All right. What I have found is that we need to try to nurture the hatching ground of where we source female lawyers in particular, so that you have a pipeline that is being readied to get in. That's one. Two, we also need to, as judicial officers, be, for want of a better word, because I don't want to come across incorrectly, but we need to nurture those practitioners that are already there, that appear before you as a judge, you know, ensuring that you are firm but fair, and not be intimidating, because it's little things that can unsettle people, especially when you find young ones coming up. So there needs to be, if I can illustrate by way of an example, when I was practicing initially as an attorney. At that time, the idea of a representative bench never even arose in our mind. And I remember the first time when I returned to practice, and I went into the chambers and I found a black judge, and I was able to say Molo judge, without the judge doing me any favor or anything. It just, I felt I belonged. I felt I can also be a judge. I was eased by that. So it's in small little things that, without taking away the integrity and the formality that needs to be maintained, because as a judge you need to maintain certain, to protect the office, but we need to also bring in humility and humanity in how we deal with members of the legal fraternity, and even persons that appear before you as unrepresented litigants, which happens a lot in court. You know, the issue of language, the issue of how much you accommodate the person, even if it means sometimes you have to adjourn court to make sure that the person gets an interpreter, so that this, because court is intimidating on its own, it's intimidating to you even as a legal practitioner that's used to going to court. So it's even worse to lay people. So it's in little things, MEC, it's in little things.
Yes, Commissioner Nogues.
Oh, thank you, CJ. Advocate, tell me, do you understand that a person who has been arrested and detained has a right to apply for bail? I mean, has a right to make bail application within 48 hours. It's just a constitutional right. We agree with
Yes, that's correct.
that. And if a bail application has been refused, he has a right to appeal if he believes so.
Definitely.
Can he be ordered to pay costs if his appeal fails?
Mr. Nogesi, I'm sure you are referring to a judgment I issued in Bisho in about about 3 weeks ago. Now and again, I always go to Safli to check latest judgments. And I picked up on I think the judgment was delivered on a Friday. And every week at least, I make it a habit to check what's up in Safli, what new judgments are there. And I picked up that there was this judgment and there was an error that I had made. It was a bona fide error in which in dismissing the appeal, I said with cause. I then requested, I then phoned Judge in Bisho, the head of the court, Judge Van Sale, and I discussed the matter with him. I told him, look, Judge, I've picked up that I've made this error, and in our discussion we agreed that, and I was suggesting to him that I'm thinking of writing another one in terms of Rule 42, varying that order, so that because it was definitely made in error. So the answer to your, I'm sorry it's a long answer, but I've had to give that explanation. The answer is it's not right to issue an order of course against an appellant in a bail matter.
Yes, I have a judgment here of Mzukis Xaxisa versus the state, in which you delivered on the 11th of March. Look, just wait for me. In this judgment, you say, I'm unable to find the magistrate erred or misdirected herself in any of the issues raised. I conclude that there's nothing wrong with the decision of the court in refusing bail to the appellant. In the result, I make the following order. The appeal against the refusal of bail is dismissed with cause. That's an order. Look, and now your explanation, which I want to get from you, is that this could be corrected by Rule 42, and can that be so?
Sorry, Mr.
What we are suggesting now, can it be done? Where you make an order which is clear in the face of the order, there's no typing error, it's an order, perfect order, application dismissed with cause. Can you simply rescind that on your own?
You can, Mr. Nogesi, on the basis of Rule 42, which I have, as I've indicated, because the rule allows for variations of orders made in a variety of circumstances. For instance, if there's an error between the parties the error is patent and so on. So when I read that judgment the following week, I had realized that that was certainly not what I intended. What I think had happened, because the day the order, the judgment was delivered, I was sitting in East London, whereas the matter, I had heard the matter in Bishop. I had then emailed the judgment, and I think my secretary must have made a mistake, and I had not noticed that I did not delete with cost, because it's absolutely not correct to include a cost order in a bail appeal matter at all.
I'll just ask for the last question, Chief Justice. So what it means, you're doing cut and paste here? Because you are saying, I did not delete the costs. You were doing cut and paste from something. Is that right?
Mr. Nokes, well, you can cut and paste what is relevant. I'll explain this. For instance, if you are dealing with a matter that you have a, which is similar in terms of the law with another, there's nothing wrong. If I could make an example, you have a case where you want to deal with versions of witnesses that are mutually destructive, and you've just researched and prepared a judgment which deals precisely with that issue. You can copy and paste the relevant portion. Of course, your copy and paste, it cannot just be blatant copy and paste of things that are also not relevant.
Thank you. Commissioner Fourie?
Thank you, Chief Justice. I'll be brief. You've delivered a judgment in the matter, I may just get to it quickly, in the matter of Tuguayo, first applicant, and then the presiding bishop of the Methodist Church of Southern Africa. Is that correct?
That's correct, Commissioner.
That was an application for rescission of judgment.
That's correct, Commissioner.
Now, as I understand the law, you can bring an application for rescission of judgment in terms of Rule 32,
That's correct.
or in terms of Rule 42,
That's correct.
or in terms of the common law.
Yes.
Those are three separate types of applications for rescission of judgment. Do you agree with me?
I absolutely agree, Commissioner.
Now, in your judgment, you inter alia say the following. I'm sorry, Chief Justice. I'm just trying to scroll down here. You say in paragraph 17, in terms of Rule 42, an application brought in terms thereof may also be entertained in terms of common law and Rule 32(1), provided the requirements thereof are satisfied. Can you explain to me what you mean by that?
There's a patent error there, Commissioner. What that paragraph should have read is that an application for rescission can be brought under those three provisions, namely Rule 42, Rule 32, and or common law.
Okay. Now,
Because Rule 42 and Rule 32 deal with completely different applications for rescission.
now, can you briefly explain to me what are the requirements to bring an application for rescission of judgment in terms of Rule 32 as opposed to Rule 42?
Rule 32, first, there must be an application, the order or judgment that you're seeking to have rescinded must have been obtained in default. And two, you must bring the application, and two, otherwise you would have defended it because you do have a defense. So you then bring the application within 20 days of becoming aware of the decision.
Okay.
Rule 42, on the other hand, equally the common law do not have the time limit as a prescription,
Okay, so-
but does require that one brings an application, and Rule 42 deals with variety of bases upon which you can bring an application. It may be an application that is granted in error and so forth.
So do I understand you correctly that you are saying the difference between Rule 32 and 42 is that in 32 there's a specific time period,
Yes,
and in 42 there's not?
yes.
Is
In
that, as far as you are concerned, the only difference?
No, as I indicated, Rule 32, there must have been a judgment that was issued without you being aware.
Now, let me make it easier for you.
Okay.
In terms of an application, in terms of Rule 32, do you have to satisfy the court that you were not in willful default?
Willful default, good cause,
And must you
and there's a
persuade
bona
the
fide
court that you have a
defense.
prima facie defense?
Yes.
Is that required in terms of Rule 42, and if so, which of those are required?
Rule 42, because Rule 42 deals with a variety, for instance, it could be that the order that was granted is an order that there was an error as a result perhaps of what the parties presented to court, or as a result of the court itself making a mistake in the order that it is granting. So therefore, you would then be guided, and in interpreting Rule 42, the guidance is sought from the common law, and the common law tends to provide a broader basis upon which you can make an application for rescission of default judgment. But what is common in all three of them is that you must have a good defense because otherwise what would be the purpose of taking all the trouble of rescinding a judgment when in fact you don't have a case in the event that the judgment is rescinded. So
If
that
I
is
tell you,
always-
if I tell you that in terms of Rule 42, you don't have to show that you have a bona fide defense.
As
Do you
I have
agree with
indica-
me?
as I've
Because you
indi-
said differently now.
No, as you would recall, Commissioner, earlier I was saying, because Rule 42 deals with a diversity of instances, and one of the instances I was mentioning is that the case would have been heard, but then the judgment that comes out could be a judgment that contains an error. So in that instance, obviously, you don't need to because the matter would have been completely adjudicated, therefore you don't even go into the issue of bona fide defense or any defense whatsoever. All that will be required is for the court to just change the error that has been made without resuscitating the matter for the hearing of the main action.
Now, without prolonging my questioning, there are requirements in terms of Rule 32, which we've dealt with.
Yes.
Am I correct to say to you that in terms of Rule 42, the only thing that you need to show is that there was indeed an error?
Yes.
So bona fide defense, willful default, those things do not come into the picture. Do you say that here in your judgment? I didn't see that.
I don't recall, but what I recall were the issues here was that I'd limited my writing to what had triggered the application in the first place, and it was very unusual circumstance in that the very respondent was in its papers saying we were not aware that there was an order granted at our instance. And yet when the applicant was bringing the application, they sought to oppose that on the basis that order should stay. So I confined my judgment to dealing with that and did not explain what the rest or what could be done in terms of the rule.
You say, if I may be permitted, Chief Justice, you say, in terms of common law, a court is entitled to rescind a judgment obtained in default of appearance, provided sufficient cause is shown. Sufficient cause is synonymous to good cause. The term escapes an exhaustive and comprehensive
Sorry,
definition.
Commissioner, where are you reading
It's
from?
paragraph 16.
Oh.
It is nevertheless settled that for the purposes of the rescission in common law, there are two essential elements. One, that an applicant has a reasonable and acceptable explanation, and two, that on the merits it has a bona fide defense. Also, there must be a causal link between the rescission and the judgment sought to be rescinded. I don't understand what that sentence means at all. But then you go on in paragraph 17, which I've already read to you. In terms of Rule 42, an application brought in terms thereof may also be entertained in terms of common law, and Rule 32(1), provided the requirements thereof are satisfied. And I suppose the requirements that you are referring to are the requirements that I've just read to you in paragraph 16. Is that correct?
Well, not quite, because in Rule 16, I deal with what pertains in common law, whereas in in the 17, I deal with what pertains in the various rules.
Well, then just explain to me.
Commissioner,
and then I'll
it's
stop.
taking too long. Just
Sorry.
put your question to her, let her answer, and then we can give others a chance.
So in terms of Rule 42, paragraph 17, an application brought in terms thereof may also be entertained in terms of common law, and Rule 32(1), provided the requirements thereof are satisfied. I'll conclude here by asking you what you mean with that. Again.
Provided that, depending on which rule one uses in bringing one's application, the requirements of that rule should be satisfied.
Thank you, Chief Justice.
Thank you, Commissioner Fourie. Commissioner Schmidt?
Thank you, Chief Justice. According to your abridged curriculum vitae, you indicate that you obtained B. Juris LLB in Advanced Diploma Labour Law. You also indicated that your dissertation is outstanding for the commercial law, the LLM.
That's
Have you
correct.
completed it?
No, I haven't.
I see you majored in shipping law.
Yes, that's
Have
correct.
you done any cases in shipping law?
Nope.
Is there a fair amount of work in the Port Elizabeth division?
I know of only one instance where I heard through the corridors that there was such a case in PE, but I've never come across any.
Thank you, Chief Justice.
Thank you, Commissioner Schmidt. You are excused, ma'am.
Thank you very much for having me.